happy New Year to you all. I hope that 2021 will bring to you and your family much happiness, great health and prosperity. I am very pleased and excited to welcome you to Space for Women Show Series 34, the new space era. What do the Artemis Accords mean for the international space law? Via the Artemis program, NASA will land the first woman and the next man on the moon by 2024, heralding in a new era for space exploration. While NASA is leading the Artemis program, international partnerships will play a key role in achieving a sustainable presence on the moon while preparing to conduct a historic human mission to Mars. With numerous countries and private sector players conducting missions and operations in cislunar space, it's critical to establish a common set of principles to govern the civil exploration and use of outer space. The Artemis Accords will describe a shared vision for principles grounded in the Outer Space Treaty of 1967 to create a safe and transparent environment which facilitates exploration, science, and commercial activities for all of humanity. So if this past year has demonstrated anything, it's the continued support of the global space family. Never has international collaboration been so relevant and needed, so we are very honored and humbled to continue to serve UNOSA Space for Women net out throughout 2020 and 2021. I'm very much encouraged by this virtual meeting between three space law experts. Ms. Donna Lawler, she's a space law specialist and principal at the Azimuth Advisory from Australia, and Mr. Professor Stephen Freeland, Professor of the International Space Law at Western Sydney University. And let me introduce you to today's moderator, will be Professor Kai-Uwe Schrogl. He's the president of the International Institute for Space, calling in from Germany. And our co-host today is Ms. Malak Trabelsi-Loeb from the UAE. She's a space law, space policy senior legal advisor, founder and CEO of Verneville Space Solution and Trabelsi-Loeb Legal Consultation. So thank you for being with us today. And the floor is yours, Kai.
Thank you very much, Yen. And also a happy new year to all of you. I'm very pleased and honored to be the moderator of this show. I'm pretty sure it will be an exciting show because we have two very distinguished and exceptional space lawyers here on the panel who will discuss with us the Artemis Accords. The Artemis Accords, as you already introduced, Jan, have been signed by a group of countries, 8 countries, on 13th of October 2020. It was initiated by the United States. And the title of the Artemis Accord reads, and I think I should read that out because it sets also the scene for our discussions. They are called Principles for Cooperation in the Civil Exploration and Use of the Moon, Mars, Comets, and Asteroids for Peaceful Purposes. Now, the US is returning to the moon. It caused already a lot of excitement around the globe. And they have already assured the partnership in this project, in the Gateway and the Artemis programs with Japan, Canada, and Europe. On the other hand, we see a number of countries, a growing number of countries, which have their missions to the moon on their own, like China, like India, Russia, Israel, but also Luxembourg. So we have a growing number of space powers, I should call them, using the moon and trying to get there, trying to operate there as well. And in this context, we have to ask ourselves, how is the legal environment for such activities? And the US have answered that by tabling the Artemis Accords. Now, let us discuss that with our two guests, as you have already mentioned. These are Donna and Stephen. They will provide us now with insights through short PowerPoint presentations, on the one hand, regarding the international legal structure of exploration and for exploration, and on the other hand, giving a very exciting case study, in particular from the view of commercial activities in this sector. Let us start with Stephen. You already introduced him very briefly. Let me say a few more words because it's important to understand the broad background of Stephen and also the authority with which he will speak to us. Stephen is Emeritus Professor of International Law at Western Sydney University. He is specializing in commercial space law, and previously he was the Dean of the School of Law there. He also holds visiting or adjunct positions at various other universities. And it is important to know that prior to becoming an academic, he had a 20-year career as an international commercial lawyer and investment banker. He's a member of advisory groups to many governments, in particular, of course, Australia. And he has been and still is, of course, a member of the delegations to UN CORPUOS. And what is particularly relevant for us today, he has been appointed by UN CORPUOS to co-chair multilateral discussions on the exploration, exploitation, and utilization of space resources, which will take place in April 2021. So this is something extremely important for multilateral discussions. And you have also indicated he is member of a number of institutions in particular, and I'm glad to have him on the board of the International Institute of Space Law. Stephen, the floor is yours for your presentation. Thank you.
Thank you so much, Kai-Uwe, and good morning, good afternoon, good evening, good night to everybody who's watching. Happy New Year. I hope this finds you safe and well, and that 2021 will be a great year for everybody. As is usual for me, I always start off by just observing that I'm speaking to you from Australia, just south of Sydney. And the land on which I speak is land that has been inhabited by humans for 65,000 years. And that's what, 2,500 generations of people who have developed an understanding of space, a knowledge of space. And to everybody around the world, I'm sure that the indigenous groups in where you live have a lot to give when it comes to our perspectives in space. Indeed, as Kai-Uwe very kindly mentioned, I'm on the advisory board of the Australian Space Agency, and the emblem that the Australian Space Agency has as its logo is a map of Australia based on indigenous perspectives on space. So I think it's always important for us to reflect that our knowledge of space, humans' knowledge of space, goes back a long, long way. Let me thank SpaceConneX and Hin and Malak and everybody associated with this wonderful program. You do a wonderful thing for the space community, and it's a pleasure for me. And I know I speak for Donna, who, full disclosure, is also my partner in life and is sitting upstairs in the same house that I'm at. It's an honor for both of us to be here. So in the brief time that I've got, let me share my screen and talk to you about the Artemis Accords. And what I thought I would do is put it in some perspective, in some context, in terms of where the Artemis Accords sit with the broader discussions, particularly, but not only, but particularly about governance structures and the exploitation of natural resources. I realize, of course, the Artemis Accords are more than just about exploiting resources, but we all understand that that is a major part of what the plans are with the Artemis program, and of course the Accords cover that. So I'll put that in perspective, work out and demonstrate for you the discussions, and then perhaps in the question and answer after Donna's presentation, we can, I'm happy to delve into a bit more detail. So the context, we're talking about lunar governance, governance of resource exploitation. I think the important thing to realize is this is not a new discussion. We are all aware, of course, that there was a great deal of excitement already back in the late 1960s and during the 1970s, excitement about the possibility of exploiting the natural resources of the moon and perhaps other celestial bodies, but certainly the moon, based on the analysis of the moon rock that the Apollo missions brought back. There was a lot of discussion about international law and how it would apply to these areas that are beyond national jurisdiction, as is space, and how they would apply to activities like exploitation. And so we had those sorts of discussions going on, leading, as everybody is aware, to the agreement by consensus at Copos of the terms of a treaty that we know as the Moon Agreement that covered exactly this topic. And as we all know, the Moon Agreement has not been subscribed to very widely and not by any of the, if you like, major space powers. But it has a lot to say about ideas that could be relevant for as we move forward to now the Artemis program and the programs of other governments. So this is not a new issue, but clearly there's a greater sense of urgency now given the technology. I should also mention that this is a political issue as well, as it was in the 70s, because those discussions about exploiting natural resources of space, like moon, came at exactly the same time as there were similar discussions about exploiting another area beyond national jurisdiction, that's the deep seabed. And you find that you had the same diplomats discussing one week the Moon Agreement terms, and then the next week the Law of the Sea Convention terms. Similar issues. It gave rise to similar political concerns. Both treaties were, the terms were agreed, and the major countries in both cases said, well, for various reasons, we're not going to sign up. And it took a long time, 12 years, until the major countries signed up to the Law of the Sea Convention. And as you know, the United States is still not a party. It didn't happen with the Moon Agreement. We only have 18 states parties, although Australia, which is also a signatory to the Artemis Accords, is one of those. And I think Donna will address that and we'll talk about it later. The other point I should make to put this in context is we have in the past come up with structures to deal with the exploitation of natural resources in space. And you're all aware that, of course, the geostationary orbit is a limited natural resource of space. There was a great deal of discussion about how that would be governed, how that would be used, giving rise to similar geopolitical tensions. And then ultimately, over a period of some years and indeed decades, but ultimately, we've come up with a governance structure that by and large works. Nothing is perfect, but it works. And so my point here is that this is a topic we've looked at before. We've come up with some ideas, and we also have shown that it's hard. You need to have proper multilateral discussions where there's a big buy-in by a lot of countries, but we can come up with solutions. There's a lot of law existing already that is relevant. And of course, I won't go through the treaties in any detail, but if you were to cast your mind through the Outer Space Treaty, that has a lot to say that is relevant for the sorts of activities that the Artemis Accord encompasses. And of course, the Moon Agreement that I've mentioned is obviously very relevant, albeit that it only represents international law for the 18 states parties that are involved. And we also have, and I hate this expression, Kai-Uwe has heard me say this many times, but we have the notion of soft law. It's not a term I like, but it, as everybody knows, that's the term that most international lawyers use. We have in the space regulatory framework quite a number, and the number is increasing, of non-traditional instruments, non-traditional in the sense that they're not typically legally binding instruments. They're not sources of international law as one would define them under the international law precepts, but they're very relevant for space activities. We have General Assembly principles, we've got codes of conduct and practices, and we've got many guidelines. And the two on the screen there are particularly relevant for the sorts of activities that the Artemis Accords envisages. So the point is that you must see it in the context that this is not new, but the technology is moving forward at such a rapid rate. Industry is pushing, governments are pushing, there's a lot of political discussion about this. It's an issue that is front and center at the international discussions and fora, and we therefore need to address it. And we have tools and we have experience, but it won't be easy. Therefore, we need to have a whole series of discussions, and that's where Artemis is very, very important. It's an important input to broader discussions. And so I've divided the discussions into three. The first level of discussions are those discussions that take place at the multilateral level, particularly at UN COPOS, and particularly in the legal subcommittee, where the idea of the exploration, exploitation, and utilization of space resources has been a single agenda item since 2016. And then, as Kai-Uwe very kindly mentioned in his introduction, last year, legal subcommittee and then endorsed by COPOS at plenary decided it was too early at that stage to set up a working group on this issue, but that this issue was so important, we needed to have a scheduled structure of consultation and negotiation to work out how we move forward. And so we have what are called scheduled informal consultations that were to already begin at legal subcommittee this in 2020. Obviously that didn't happen, but will now happen in 2021. And I have the honor, along with a wonderful, wonderful lawyer from Poland, Andrzej Michtal, who was a former chair of the legal subcommittee, to co-chair those discussions. We're getting lots of input from states, parties, the 95 member states of COPOS, and we want more inputs. Then there are, and this is where the Artemis Accords fall in, there are a lot of bilateral or national initiatives. We've seen the 2015 legislation in the United States, the 2017 legislation in Luxembourg, the recent legislation in UAE that is relevant for these sorts of issues. 2020 saw the Trump administration move forward quite dramatically on this, with firstly an executive order in 2020, the publication of the Artemis Principles, which were the headlines for the Accords, and then subsequently, as Kai-Uwe mentioned in October, the Artemis Accords were published, and we had the 8 and now 9 with Ukraine, other countries, space agencies signing up on a bilateral basis into these accords. These accords are not treaties, they're not legally binding, they're political understandings, but clearly they have legal effect on the signatories involved. But of course, other countries are engaged in similar activities, they have similar ambitions. Kai-Uwe has mentioned India and China, and of course, Israel and France and other countries outside of those that are involved in Artemis also have ambitions for the sorts of activities that are envisaged. And then there's been a lot of work done at the civil society level. I've mentioned a few there, and forgive me to those other NGOs who aren't mentioned here, but there's a long list of NGOs that have looked at this issue, have given their own views based on expert reports and whatever. And of course, there's also the plans of industry that are constantly being refined further and further. Business plans are being created that now seem more realistic than the initial business plans. And my point with showing you this slide is, one, to say, put Artemis in a context. It's an important input, but it's one of many inputs that, at least in my view, ultimately, for issues like what we are talking about, for issues like what Artemis envisages in terms of activities on celestial bodies and exploitation and extraction of resources, in the end, we will need to have a broad buy-in from a broad range of countries. This is an issue that really defines our relationship with space moving forward. And all of the inputs at that national and bilateral level, including, importantly, the Artemis Accords, all of that work by civil society, all of that is important in informing the broader multilateral discussions that will take place, again, starting in early this year at Legal Subcommittee, so that ultimately, when the international community decides how to progress, it's not starting with a blank piece of paper, but it's getting this incredibly important and detailed inputs like Artemis, where a lot of work has been undertaken. There's so many good ideas, although there are other ideas that will go into that need a lot more thought and discussion, and not everybody agrees with them. But all of these, including Artemis, are important inputs to a broader agenda, which is ultimately where we can gauge and the understanding of the broader community, including, of course, not just all of the major spacefaring nations, but indeed all of the stakeholders, including all of the member states of COPOLOS. And then ultimately that will allow us to move forward, as we have in the past, move forward with these sorts of ideas in a way that maintains stability, security, safety, and sustainability in space. They are the important issues that will keep space being utilized for peaceful purposes. Artemis is an important input into that process. It's not the only one, but clearly there's some interesting and important notions in there which everybody must look at carefully. So I'll stop there, and of course, we'll be very, very happy to go into more detail when we go to the Q&A. Thank you so much, and I'll pass it back to you, Kai-Uwe.
Thank you very much, Stephen. Thank you very much indeed. That was an outstanding introduction to the issue, and nobody could better than you present the context for the Artemis Accords. We hear so often this misunderstanding: the Artemis Accords are the next moon treaty. And if you are not participating in that, you will not be allowed to go on the moon. Well, I'm now overdoing a little bit, but you made so wonderfully clear that the Artemis Accords are an extremely important input. And one input amongst others, you mentioned the Hague Working Group, Moon Village Association, and so many other also NGOs, that this is the context for which the Artemis Accords will also compete with the other ideas. And you will be in a key position together with Andre Mistal to filter out what will be put before UN COPUOS in order to be the basis for multilateral discussion. So it's an extremely, extremely important mission you have. Okay, now let's turn to the second presentation. Donna, we are very keen on listening to your perspective, which is a commercial perspective, but let me introduce you before. Donna is a founder and principal at Azimut Advisory, Australia's first law firm dedicated to space activities. She is an experienced commercial lawyer specializing in complex transactions involving space activities, and Donna has negotiated a lot of contracts for the build and launch of geostationary satellites, and advises also on all legal aspects of space-related missions. During her 20 years in the space industry, she has been an advisor to spaceport operators, launch service providers, large and small satellite operators, lunar missions, and aspiring space resource companies. She's also a member in the International Institute of Space Law and a member of the faculty at the London Institute of Space Policy and Law. Donna, please, the floor is yours.
Thank you so much, Kai-Uwe, and thank you, Hien and Malak, for having me, and thank you to Space for Women. It's a fantastic event, and hello to everybody out there that I can't see. I wish I could see your faces, but I hope there's a few people out there listening to us opine on these issues and who are interested and even passionate about the moon. I will just quickly outline why my thoughts about why people have a commercial interest in the moon. I want to tell you briefly about 2 private Australian missions to the moon that are currently planned by clients of ours. And I will use that as a little bit of a case study to talk through what the Artemis Accords are going to mean for commercial operators who are planning moon missions, or even non-commercial operators. But what's it going to mean when they go to get a license from, in our case, the Australian authorities for a private moon mission? What are the Australian authorities going to be taking into account when they determine the conditions that they are going to impose for a private mission to the moon? And having regard to the likely concerns that our regulators are going to have, what should our clients be planning for? What should these private lunar missions be already planning in? Because you need, before you even make your application to your national regulator, you need to have planned your mission and designed it. You'll be building technology, you'll be entering into contracts. And by the time you actually start to get an idea from the regulator what the conditions of your license are, it may be too late in your design phase. So we have a chicken and egg problem. If you have a mission that's going to take several years to plan, you need to start thinking now about how you're going to design your mission. What legal points do you need to think about that you may not even know about for another two or three years. Okay, so why are people even interested in the moon? Isn't it just a big dead rock? Well, the answer is the moon is rich in resources. So recent missions by the Chinese, the Americans, the Indians, and others have determined that there are all sorts of potentially valuable minerals on the moon, including, and most importantly, for the initial missions, there is water. So that will certainly be an important resource to have. Certainly, if there is ever going to be some sort of habitation on the moon, you'd want quite a lot of water to be there to support you. But also, there is a plan for NASA to use water, and also some private space transport providers, to use the water as fuel in order to get to the next big destination, which people have their eyes on, and that is Mars. And as we know, Malak, you must know very well, the UAE has just sent a very ambitious mission out to Mars to have a look to see what's out there. So that's where everybody's eyes are, but the stopping point along the way is going to be the moon. So Australia is no exception. Australia has identified as a special, our special niche technology. When Australians have sat down and thought, what are we good at? What could we do in space? What we are good at is remote mining operations. So Australia has been focusing on its ability to use artificial intelligence and robotics to run massive mining operations at a very long distance. And so the Australian powers that be and companies, certain companies, think that we might have an ability to help NASA obtain water and other minerals from the moon. And as a result, Australia is very interested in being part of the Artemis program. And our Prime Minister has even said that they're going to dedicate $150 million to Australian companies to enable them to become part of the Artemis program. So there are two private consortiums which haven't particularly been endorsed by the Australian Space Agency, but two private efforts. One is called the Seven Sisters, which is planned for 2023, and some of our clients are looking to be involved in that mission. And the second one, second in planning, but they actually announced first, is one called Lunar Ascent. And that is being run by a new company called Space Machines, which is a space transportation company. They are building space tugs to transport small spacecraft between orbits and even to the moon. And they have put together a not-for-profit consortium of companies that are planning to work together to get to the moon in 2024 using their orbital transport. So two very interesting missions. It'll be interesting to see. It's kind of funny that they both announced within a week of each other, both from the same country, but we'll see what happens with the planning of those. And I certainly hope that they're both successful. So meanwhile, having a look at the past of licensing of private moon missions. There has been, as you know, one private moon mission that attempted to land softly on the moon. They did successfully make it to the moon, but they didn't successfully land on the moon. It was authorized, I assume, by the Israeli government. It was called Bereshit, I think you pronounce it. And it was also, the launch and the transport were authorized by the Federal Aviation Authority in the US. But it didn't entirely go to plan because it turned out that there was some unplanned passengers on that mission. This very strange looking and almost horrible looking small animal is called a tardigrade. There was on that mission, there was a slide of some spores containing tardigrades. They didn't look like that because they would have been in spore form. And I guess the point is that the regulators, at least as they say, weren't aware that the tardigrades were there. So that was an effort to regulate a private mission, which possibly does breach planetary guidelines, the planetary protection guidelines. The moon has now been contaminated, some might argue, by these little spores, and it wasn't properly authorized or supervised by any regulatory authority. So I would say from a regulatory perspective, it wasn't a big success. So the Australian regulators are going to be certainly hoping that they can avoid another event like unlicensed passengers going to the moon. In Australia, space launches need to be licensed under Australian law. We have some legislation called the Space Launches and Returns Act. And so any Australian company that is seeking to go to leave planet Earth is going to need to, or with an object that they own, is going to need to get a license of some form. So our Australian authorities are going to be thinking about how can we make sure that any Australian mission complies with international law. Of course, the Outer Space Treaty and the other treaties, but in Australia's case, also the Moon Agreement, which Australia has signed up for. Balancing act, Australia has now also signed the Artemis Accords. So to the extent that there is that there are gaps or discrepancies between the two, they're going to have to walk that fine line and make sure that private organisations comply with both of those, albeit that the Artemis Accords are specifically designed and expressly designed to apply only to civil space authorities that are working together with on the Artemis Accords with NASA. They don't expressly apply to private organisations that are not representing the Australian Space Agency. But my guess is the Australian Space Agency will be quite keen to make sure that the whatever private organisation goes to the moon complies with both the Moon Agreement and the Artemis Accords. So I'm just going to very briefly go through some of the fine lines that the Australian Space Agency is going to have to walk when they are licensing an Australian lunar mission. And for which our private clients who are thinking about going to the moon are going to need to plan even long before they even start applying for licenses. So they're going to have to plan to share data in some form. Already under the Moon Agreement, there is an obligation to publish information on your mission, the time, the purpose, the orbital parameters, and the scientific results. There is a little bit of wriggle room that the things have to be, information has to be published to the Secretary General of the UN and to the public and to the scientific community as much as is feasible. Under the Artemis Accords, signatories have made an express commitment to open sharing of scientific data. Although, as later we'll see, there are some exceptions for private organisations. Under the Moon Agreement, any resources that our Australian lunar missions find are going to have to be shared to the extent feasible and practicable. You can imagine if you spend a lot of money getting to the moon, perhaps you aren't going to want to share all of the information, but that will be an interesting discussion for them to have with the Space Agency about what is feasible and practicable to share. And to some extent, the Artemis Accords have given one interpretation of what it might mean to be transparent about your discovery. There is a commitment to open sharing of scientific data, but those commitments, they have expressly said in the Artemis Accords, are subject to proprietary information and export controls. So there is an ability to keep things secret if you are a private company that is not acting on behalf of NASA, or if it's confidential information, or if it's subject to export controls, there's a very broad scope of information, particularly to do with rockets and encryption, that will be covered by that. Okay, so the Artemis Accords is also very concerned with coordinating with other space actors, and that topic is also dealt with in the Moon Agreement. So if you are under the Moon Agreement, if you are a states party operating in a particular orbit or area, you need to coordinate with other states parties that might be operating in the same orbit or area. And the same and very similar concept is dealt with in the Artemis Accords. There is a lot of discussion about avoiding harmful interference, about having due regard for the activities of others, and by coordinating with relevant actors using a new concept called safety zones. And I think we'll talk a little bit more about safety zones later in our discussion, but there is certainly a concept that safety zones need to be, signatories of Artemis Accords have the ability to declare a safety zone if there is a chance that there may be some harmful interference by other actors, with the proviso that the safety zones need to be temporary and reasonable, having regard to the activities. So this is a new concept. It's not one that's currently in international law to my knowledge, but I think the NASA and the United States is trying to promote this concept. The Moon Agreement itself also talks about avoiding interference with the activities of other states parties. Similarly, the Artemis Accord says that signatories are to respect reasonable and temporary safety zones in quotes. So, and there is a commitment by the signatories to the Artemis Accords to further develop the concept of safety zones. So lastly, I'll just briefly touch on the idea of sustainable operations, which is really dealing a lot with the space resources. So this is where we get to the nub of the issue in both in the Artemis Accords and the Moon Agreement. The Moon Agreement is often portrayed, particularly by some academics in the United States, as being anti-extraction and use of moon resources and space resources. Whereas my particular view is that the Moon Agreement, its raison d'etre is to provide a framework for the utilization, extraction and exploitation of space resources. In fact, Article 6 expressly allows states parties to use moon resources to support scientific missions. So that's expressly there today, even before there is any international framework developed, one might argue. There is if you were to land on the moon today, you could use resources of the moon lawfully under the Moon Agreement to support your scientific mission. So to my mind, that is perfectly consistent with what we see under the Artemis Accords, which is talking about extraction of space resources, benefiting humankind by supporting sustainable operations. We'll talk a little bit more about space resources in our discussion, no doubt, but I just wanted to flag that these two documents, while they are often pitted against one another, they're perhaps more consistent than people initially realise. Another aspect of sustainable operations, states parties under the Moon Agreement are required to avoid harmful contamination of the moon. So hopefully no Australian parties will be sending any tardigrades there. The Artemis Accords don't mention harmful contamination in the same way, but they do have a particular environmental concern, and including the mitigation of orbital debris. So Australian law is already quite strong on the need to have a debris mitigation plan and to demonstrate that there's going to be compliance with international guidelines in that regard. So our lunar missions will already be planning for that. Last little point before I'll stop and we can perhaps just start our discussion. The Moon Agreement talks about consideration of international scientific preserves. So there is the Moon Agreement was very concerned with not only use of resources, but also scientific exploration. And there is consideration that perhaps there may be development of some form of protection for international areas, sites of scientific interest. The Artemis Accords doesn't talk about sites of scientific interest. Instead, it is urging signatories to preserve outer space heritage, and in particular the Apollo 11 sites. And indeed, on the last day of 2020, the United States government passed some new legislation, the One Small Step laws for protecting human heritage in space. Once again, very focused on Apollo 11 landing sites, but it's an interesting shift. Back in 1979, we were talking about science, and now there is more of a shift, perhaps in response to some particularly lobbying by people concerned with space heritage to protect that aspect. I'll stop there, but that hopefully gives us enough to continue a bit of a discussion, comparing and contrasting the requirements as they'll apply to private missions that are licensed in Australia. Thank you, Kai-Uwe.
Thank you very much, Donna. This was excellent. It's very much complementary to what Stephen presented. And I was thrilled to see that there is a inner Australian race to the moon with these two
it's a race.
and the two programs. It's fantastic. Let's see who will be the first. So thank you very much again. And it was a perfect presentation to start the discussion. And I would kick off the first question to Stephen, and it's based on what you, Donna, presented when comparing Moon Agreement and Artemis Accords. You have said, and we have seen that some of the Artemis Accords elements are restatements and reaffirmations of existing space law, including the Moon Agreement. But the question also arises, is this just cherry picking? The US took what they liked and disregarded what they did not like. And where is the additional legal element? Where are the additional legal issues which are brought forward by the Artemis Accords? Stephen, could you start with responding to that?
Yeah, absolutely. Thank you, Kai-Uwe. So a lot of people say, and the Artemis Accords have been projected by many as being just a reflection of the Outer Space Treaty, perhaps implementing the Outer Space Treaty, that's the word that's used, operationalizing, which is a horrible word. Those are the words that are used by those that promote the Artemis Accords, implementing the Outer Space Treaty, and therefore relax, there's nothing new. Well, as Kai-Uwe said, the Artemis Accords does, to its great credit, reaffirm not only some principles from the Outer Space Treaty, but reaffirms the what the Americans call the 4 core treaties. So there's no mention of the Moon Treaty, but there is mention of each of the others in the preamble. It also reaffirms other things like the long-term sustainability guidelines. It's clear that the Artemis Accords are promoted as being centralized around the Outer Space Treaty. So if that is the case, then it should in every way, shape and form reflect international law as we know, and not add more. But in fact, it does add more, and in fact, it varies from international law. So I won't go into the issues that Donna raised about the Moon Agreement. Let me look at some more even fundamental issues out of the Outer Space Treaty. Just a couple of things, and there are many that could be raised, but a couple of points. Firstly, on the issue of peaceful purposes, we all understand how important peaceful purposes are. We all understand that the Outer Space Treaty, and this is reinforced also in the Moon Agreement, say that the use of celestial bodies, including the Moon, shall be exclusively for peaceful purposes. Now, the Artemis Accords doesn't disagree with that, but it subtly changes it by saying the Artemis Accords are just about civil activities by civil agencies, and those activities are to be engaged in peaceful purposes. Now, that's not conflicting, but what it does is it adds this element of what I would say unnecessary uncertainty by saying, well, that sort of assumes that maybe there are other sorts of activities that might go on celestial bodies, and that they may not, and I'm sure this is not what is meant, but that those other activities may not necessarily be peaceful. And we know that is contrary to the Outer Space Treaty. So I would have loved to have seen in the Artemis Accords a clear statement reflecting the words of the Outer Space Treaty: every activity is exclusively for peaceful purposes, not to bifurcate the activities. And this gets down to some enforcement issues about safety zones. So that's one point. Another point is on non-appropriation and the exploitation. So Article 10 of the Artemis Accord says that, as Donna said, space resources can benefit humankind. All of that is good. But then it says that extraction does not inherently constitute national appropriation as it exists in Article 2 of the Outer Space Treaty. That's an interpretation that the Artemis signatories have put on the notion of extraction, in a sense, not in and of itself ever being national appropriation. That, of course, has been the subject of much debate, including by the Institute of Space Law. We, under Kai-Uwe's leadership, put out a statement on this. I like the fact, though, that the word inherently is still in there, because essentially what that's saying is, well, in and of itself, this is not appropriation, and in fact, that's consistent with the Moon Agreement as well. But inherent means that there may be other factors, and so we need to make sure that it's not understood that this is a statement saying extraction can never be an appropriation. It's saying inherently we must look at the circumstances. Another point is the heritage point that Donna made, and so I won't go into that in detail, but heritage is not an issue that is reflected in the Outer Space Treaty, but I make the point, I reinforce the point by Donna, it is, the heritage protection is narrower than the notion in the Moon Agreement, albeit the Moon Agreement's only got 18 states parties, we understand that. But the Moon Agreement talked about preserving areas which have scientific interest, and scientific, most people agree, extends to cultural and heritage as well as pure science. And Artemis just talks about heritage sites. And indeed, the new legislation that Donna mentioned just talks about the Apollo missions and those heritage. So it's narrowing what has generally been accepted in the terms of the Moon Agreement, when that was agreed on a consensus basis on the way that we should think about these areas. And another, and then I'll stop Kai-Uwe on this question, although there are many other issues, is the issue of safety zones. This gets to a point where it's a reflection, as is stated, about notions of due regard and protecting harmful interference, but it raises so many questions. And let me just, to illustrate, give you a point. I spoke very recently about space mining issues at a conference of miners in Australia. And as Donna said, Australia is a huge mining country. And someone asked me a question about, and they called them the exclusion zones. And I said, no, they're not fashioned as exclusion zones. That word, that concept does not exist in the Artemis Accords. They're safety zones. But the mining community said, well, we're not interested in that. We need exclusion, because the way mining works is you don't mine seamlessly from day 1 to day 20. You go, you explore, you work around, you then analyze your exploration, you have to come back. And then when you decide where you're going to mine, you have to go and prepare for that. And there are long periods there. And so the enforcement of those long periods, given that they should be reasonable and temporary, as the Artemis says, will give rise to questions about, well, can others come in, other Artemis parties? But more importantly, of course, there are many, many other countries that may not be party of the Artemis Accords. For them, safety zones is not a concept that we recognize in international law as yet, and that will give rise to other issues. Now, there are probably a dozen other points I could raise in answer to the question. Artemis does reinforce some international law. It changes the nuance of existing international law. It adds additional things, and that gives rise to questions. So I think on the legal front, I'm not saying they're necessarily bad things, but they're certainly not, this is not customary law. People are saying, oh, here we are, this is state practice. Well, as we all know, any country doing something is state practice. What we need to reflect international law is state practice of a sufficient amount by a broad range of countries who are engaged in that activity and others for a consistent period of time. And as important as Artemis is, the fact that 8 or 9 countries have signed this is not sufficient state practice to say all of a sudden this is law. So I think on the legal front, there are some positive things, but there are many, many issues that I think we need to address at international law. Thank you, Kai-Uwe.
Thank you. Thank you very much, Stephen. You covered the Outer Space Treaty, I understand. Now, Donna also mentioned the Moon Agreement. And this is something a lot of people have already pointed at, that Australia, amongst these 8 signatories, is a state party to the Moon Agreement. Now, let me ask Donna again, and very dedicatedly, does this pose a conflict for Australian lunar missions, being a state party to the Moon Agreement? And I should also extend that question because, and you also indicated that, Stephen, the Moon Agreement was open for signature in 1979, but before it passed the UN General Assembly with a unanimous vote. Now, this means also, and I don't use the term soft law for UN General Assembly resolutions. All member states of the United Nations at that time, and all these countries we are talking about now have been member states of the United Nations at that time, they agreed to the text of the Moon Agreement. They did not sign or ratify them, except the 18 countries which did so, but they adopted this text. So while they are not universally acknowledged as a treaty law, it is, well, universal soft law. Now, Donna, in view of the character of Australia as a state party to the Moon Agreement, are there any conflicts which arise from now participating in the Artemis Accords?
Yeah, certainly that question was one that was top of mind for a lot of Australians, and I imagine other Moon Agreement countries like the Netherlands, when Donald Trump published his executive order, which was very expressly anti-Moon Agreement. And the elephant in the room, I think, is ownership of space resources. So the Moon Agreement expressly describes the moon as the common heritage of mankind, it said then. We would now say humankind. A lot of United States commentators try very vociferously to argue against the common heritage concept. And the executive order appeared to be clearly rejecting that. The Artemis Accords, there was some concern that the Artemis Accords, before we saw the actual text, would have language that expressly spoke against the common heritage concept that's in the Moon Agreement, and which is, I believe, agreed to the idea of space as a commons and belonging to everybody as opposed to belonging to nobody, is, I think, subscribed to by many countries in the world, not just Moon Agreement countries. And so I felt that the Artemis Accords, and I'm certainly not speaking for Stephen here, but my own personal view is the Artemis Accords were trying to edge away from that common heritage concept and trying to edge more towards space belongs to nobody, not everybody. And certainly that is reflected in the domestic law in the United States, where they've tried to say, well, anybody that mines any, extracts any resources on the moon and from asteroids is the owner of those resources. Although at the end of that legislation, even in the United States, subject to international law. So for the person who digs up the resources to own the resources under US law, it needs to be in accordance with international law. Certainly that's how I read it, which I think becomes potentially a little bit circular. So what that means is there are those in the United States who are then, I think, a little bit desperate to say, no, we want to own the resources if we dig them up. The common heritage concept puts that in jeopardy. And therefore, you know, let's issue an executive order along those lines, and let's try and encourage our allies who want to join with us and enjoy the financial benefits of being part of Artemis to agree with our interpretation of international law, which is going to give us this leeway. But what I suspect has happened is the Moon Agreement countries and perhaps others have negotiated the text of the Artemis Accords. This is pure speculation on my part. I don't actually know what they did. It looks to me like they've negotiated. And in fact, what we have is there is nothing in the Artemis Accords that says that the moon is not the common heritage. And we see nothing about owning resources. Instead, what we see is a fairly general and I think political statement, which is all cooperative activities should be carried out in accordance with the legal obligations applicable to each signatory, which if you were just reading it and you didn't know this whole controversy, you might just skip over. But when I see that language, I tend to read, okay, this is the agreement, this is the language they have negotiated with the Moon Agreement countries to enable them to enter into the Artemis Accords. So I believe that many of these sentences have been tweaked. The Americans would like them to be a lot more express to reflect their view of international law, the way they'd like it to be. The Australians and possibly others have pushed back a little bit and have softened the language a bit. That is my speculation. So I think, yes, Australia can act consistently with both the Moon Agreement and the Artemis Accords, but I imagine that is as a result of negotiation.
This is extremely interesting. It's also promising, I would say, that this kind of possibly also artificial dichotomy between the two texts might not exist. You pointed out in your first intervention that the Moon Agreement enables the use of resources. It also is, I should not say, but it comes to my mind, a kind of propaganda against the Moon Agreement to say that the Moon Agreement is against exploitation of resources. No, to the contrary. This is why it also says we have to set up a regime. And this now turns to the political question, and I might also turn again to Stephen. It is about fairness. Fairness as a concept also of international law and of international space law as well. Look at the regime for the geostationary satellite orbit. It was set up after we had the principle of first come, first served. And we then developed into a regime which is more equitable and more fair. And the question arises, are we seeing a threat of exactly the same first come, first served with the extraction of resources on the moon, which is kind of pushing away the concept of common heritage of mankind and violating also principles of the Outer Space Agreement as treaty as the non-appropriation principle, or can we still harmonize that? Stephen, what is your view on this more political than legal question?
Yeah, thank you, Kai, and I think it's a wonderful question. Thank you so much. I think that one can harmonise. I think the points that are made about the Artemis Accord, neither none of us in this room were privy to those discussions. But clearly, for Moon Agreement countries to become parties, to become signatories, they have to be satisfied in their own mind that there's no conflict. And I can announce that I know the Australian government, this is public knowledge, will be making a statement on their interpretation of the Moon Agreement, which no doubt will accord with it being with the Artemis Accords not in any way violating their obligations. So the centrality of the Artemis Accords, and even in that executive order, which we all remember, you wrote about it, Kai-Uwe, and I did, had really strident language about many issues. It denounced the Moon Agreement to a certain degree. It threw away, from the American perspective, the notion of global commons. But it kept on saying the centrality is the Outer Space Treaty, as does the Artemis Accords. It keeps on pointing back to the centrality of the Outer Space Treaty. So in the end, as Donna says, all of these issues are going to be determined by international law, starting with the Outer Space Treaty. And the Outer Space Treaty is clear. It's clear that activity should be for the benefit and the interests of all countries. It's clear that they should be done on a non-discriminatory basis. It's clear that there are issues of free access. It's clear that states will take responsibility, etc. All of the issues that I'm sure everybody in the audience is very familiar with. And so I cannot see any of the Artemis signatories willingly wanting to diverge from that. And in good conscience, they wouldn't do it. I'm sure the Australian government wouldn't do that. I'm sure none of the other parties will. So in the end, they have to make it work. Just like, as you said, Kai-Uwe, we had to make the geostationary orbit work. Nothing is perfect. And the first come, first serve, it still operates, but we also have the equitable access. We found a way. Nothing is perfect. Likewise, in the Law of the Sea Treaty, we found a compromise that brought in every major country, as I said, apart from the United States. We will find a way forward. We will take lessons from the Moon Agreement, although given the way the Moon Agreement is regarded by some countries, we won't be saying, oh, let's copy the Moon Agreement, but we'll be looking at the lessons from that instrument. We'll be looking at the lessons from Artemis and all the other things that you and I mentioned that I had in my slide. In the end, the notions of common heritage, even if you read the Moon Agreement, notions of common heritage in that Moon Agreement and the interpretation by 8 of the Moon Agreement countries in 2008, I think it was, at Legal Subcommittee, said this means what we believe it to mean in taking into account technology and politics and everything at the time. It's a fluid concept. It's not a rigid concept. And so it is not a restrictor. It is a concept that would allow us to move forward in some way. So I can see, given that humanity has decided we should be doing these activities, and that's one big question that seems to have been answered, even though I'm not sure we had the full debate, given that we're moving forward to do these activities, we have to find a way. Because if we don't find a way, the consequences of that would be environmental catastrophe, political catastrophe, conflict, etc. Is space a global commons? The United States in the executive order said, well, we don't regard it as such. Okay, they may not regard it using those words, but if the centrality of everything is the Outer Space Treaty, the very premise of the Outer Space Treaty is that this is an area that somehow we have to work together in some way, shape or form to utilize in a peaceful and sustainable way. So I wouldn't be doing, we wouldn't be doing what we do if we didn't think we could find a way forward. It will be difficult. There are many vested interests, many different perspectives, but I think everything can be reconciled. But the final reconciliation will not be a copy paste of the Artemis Accords or of the Outer Space Treaty in a sense, although it won't conflict with the Outer Space Treaty, or indeed of any other instrument. It'll be an amalgam of the really good lessons we can learn and put that together in the best possible way. So I am confident, but there's a lot of work to be done, I think.
Thank you. That's very reassuring, Stephen. Thank you very much indeed. Now we covered legal and political aspects. Let's turn to Donna to have another look on the very practical aspects of the Artemis Accords. Your companies, in particular, the two who are doing the space race, the Australian space race, yes. So far they had to consider the provisions of the Moon Agreement and your national license obligations. Are there any additional planning requirements for them resulting from your participation in the Artemis Accords?
Well, I think I mentioned already the orbital debris mitigation aspects, which are already in Australian law, already contained in other aspects of international law and guidelines, but which are expressed with more specificity in the Artemis Accords. So certainly we'll be looking at those to make sure that at a very early stage, any hardware that is being developed complies with those guidelines, and the mission planning takes that into account to make sure that it's environmentally responsible as well as compliant with all of these aspects. I think the one early interesting activity is going to be the planning of the orbits around the moon and the consultation around that. So the Artemis Accords are very keen on transparency, getting people to be transparent about what their signatories to be transparent about what their missions are and what the reasons, what are they doing and why. At least to the extent that they're civil activities, they're not binding their military's hands with these accords at all. But I think our clients are certainly going to have to plan and consult on the location, plan the location of their activities, plan which orbits they're going to use, and I believe also what spectrum they're going to use in those orbits, because we don't have the ITU governing orbits around the moon at the moment, so that will be an interesting aspect. And then consult. So the one very positive thing in the Artemis Accords is the emphasis on consultation with other space actors. So to the extent that we're aware, and we're only just now aware that there are 2 Australian lunar missions, so they're going to have to consult with each other, and as well as anybody else who happens to be going to the moon. They may need to think about declaring a safety zone. That could be interesting, both Australian missions declaring a safety zone and then negotiating that with one another. And they may need to comply with other safety zones declared by other Artemis Accord signatories. So that could be a new concept which we actually have to work with in practice. Even though it's, not part of international law, it might become part of the practice of Artemis Accords signatories. Of course, our clients will have to make sure they avoid damaging space heritage sites and scientific sites of interest. They will need to share scientific results where appropriate and feasible. The Artemis Accords, I don't think, requires any more sharing than does the Moon Agreement already. But there certainly is a principle of sharing, but they're pretty careful to say in the Artemis Accords, oh, but that doesn't apply to private entities. As our private entities are doing remote sensing of the moon to see where resources are, it'll be interesting to see how comfortable they feel sharing that information, given that previous missions have shared a lot of information about resources. That's why we know what we know so far. And then lastly, we'll certainly have to avoid harmful contamination. That's looking once again at a Moon Agreement obligation. But it's going to be a little bit of an interesting ride, I think, Kai-Uwe.
Oh, indeed. Yes, there are. Thank you very much for pointing out the innovative and interesting aspects of the Artemis Accords, resulting from identifying practical issues, in particular for coordination amongst states and amongst projects. And this is certainly a value of the Artemis Accords. Everybody, even the critics, are sharing in. On the other hand, there are these concepts, and you both have pointed at one of them, the safety zones, which give rise to a number of questions. So let me ask one question to both of you, and maybe Stephen can again start, and you give your view on that. The safety zones, it sounds reasonable, of course, firsthand, but is it also a potential source of conflict if somebody says, this is my safety zone, without having a clear set of criteria of how such safety zones should look like? Also imagine that somebody is stepping on an asteroid and says, well, the safety zone for this activity is the whole asteroid. So is this also appropriation? And then think ahead. Why should we only have safety zones on the moon? Why shouldn't we have safety zones around satellites in orbit, in GSO, low Earth orbit, or a safety zone when you have a mega constellation, so the whole orbit plane is your safety zone? What are we kicking off with establishing or talking about, or considering at least, safety zones on the moon through the Artemis Accords? Stephen, please.
Yeah, well, what we are kicking off is that space law people will have a job for life, I think, trying to work through all of the questions that arise. It's an excellent question. As we've said, the safety zone is a concept that we haven't really seen in international law, certainly not in international space law. So it's interesting because Artemis, in the same article, in the same section, reaffirms notions of free access to all parts of celestial body, but then it talks about safety zone, and the notion here is that safety zones will help to avoid potentially harmful interference, and it's part of due regard, and it's a really positive thing. So it certainly, on that level, can be seen as a useful tool, but it raises so many other questions. The question of consultation, for example, that Donna mentioned, and that's in Article 9 of the Outer Space Treaty. Artemis says that an Artemis signatory can request consultation with any country, any space actor, if they believe that actor's activities might harmfully interfere with them. But the obligation on Artemis signatories is only in terms of their own activities to do everything to avoid harmful interference to any other Artemis signatory. So again, that's not in conflict with the Outer Space Treaty, but it's a nuanced narrowing of what the Outer Space Treaty requires, which is it's a two-way street. You know, you have to take account of everybody's interests, not just a small select group. Remember, for the benefit and the interests of all countries, and also Article 9 of the Outer Space Treaty. So safety zones will raise a lot of issues. The obvious issue, although there are many more, is that, of course, I've given a practical example of how, you know, the timeframes are going to be difficult, you know, because miners and think of exclusion while they prepare for the next phase of their extraction operation. How is that going to work? Miners think of these things as exclusion zones. They're not expressed to be. What effect do they have on non-Artemis signatories? That's the obvious question. And how then will that be enforced? And this gets back to these activities that, you know, there's this uncertainty now about, are there activities that aren't civil activities that don't fit into peaceful purposes? all of that just raises questions. Your example about landing on an asteroid and saying, well, I need a safety zone for the whole asteroid, really points to the notion I made before, that that word inherently means you've got to look at everything on a case-by-case basis, because there's strong suggestion that that might be an appropriation. I mean, nothing is certain, but clearly the evidence points. And then when you then start talking about safety zones, or whatever you call them, in orbits, around satellites to protect particular orbits for mega constellations, you really are challenging notions, fundamental notions out of the Outer Space Treaty. I'm not saying it's a deliberate violation, but you really challenge non-appropriation. You really challenge freedom. You really challenge benefit and interests. And we're already beginning to see large constellations being concentrated in very narrow orbital planes. And so is that if you like, a control of an orbit by stealth? And what stealth, essentially in practice excluding others from being able to use it? These are really difficult questions, which is, everything points to the fact that we really need to get everybody in the room and thrash this out, because if we assume that Artemis or another equivalent of Artemis with a small number of countries is the answer, well, that might be the answer for those particular countries, but others aren't in any way, shape or form necessarily going to agree or comply with that. Why should they do that? So I think your question is absolutely right. There could be some really positive aspects to having a safety zone, but we really, really need to understand it. And when you read the particular article in Artemis, it doesn't say very much about safety zones. And it really, the devil will be in the detail and how that works. And we will find a way, as we do with GEO and other places, but we're certainly not there. I think I end every intervention saying the same point, but I think it's worthwhile reflecting that these are really interesting concepts. They may be useful, but we still need to really, really understand and look at this on a holistic basis. Thank you.
Thank you. Thank you, Stephen. Donna, your view on that?
Yes, I think when we all first read the concept of safety zone, I think we all thought, or many people thought, oh, they really mean exclusion zone. They're saying safety to make it sound more attractive and more acceptable, but they mean exclusion. But then when you go into the terms, the actual text of the Artemis Accords, they do indicate that they expect that signatories, they affirm, perhaps reluctantly, the right of other signatories to enter into their safety zone, and it seems to be more about coordination. But I suspect that the real desire is to de facto use due regard and non-interference and harmful interference as de facto way of saying, and when it comes to resources and orbits, it's first come, first served. Whoever gets there first can exclude everybody else, and anybody else who comes within my safety zone is jeopardizing my safety, causing harmful interference, not showing due regard. And so it does it may in practice, if it plays out like that, start to look like appropriation. And I would, I actually much prefer, and you will have guessed that I'm a bit of a fan of the Moon Agreement. I would much prefer the language that they use in there for the scheme. And I know that the Moon Agreement is probably not going to be the basis for the ongoing discussions in the working group where Stephen is chairing or co-chairing. But some of the language used there is orderly and safe development of space resources. I think, rather than first come, first serve, what we're trying to get to is orderly and safe development of space resources, rational management of resources. That's a phrase used in the Moon Agreement. Expansion of opportunities in the use of resources. That's a phrase used in the Moon Agreement. And then lastly, the equitable sharing of benefits, which is the area that raises the hackles of some in the US although it certainly doesn't say equal sharing of benefits. It says equitable sharing of benefits, having regard to the needs and the contributions. So if you've put a lot of money into something, then that should be certainly recognised as part of the equitable sharing. And it's sharing of the benefits, not of the resources. So I would just say safety zones, yes, we all agree with safety, but let's make sure that they don't become de facto exclusion zones or de facto first come, first served, or de facto we don't accept any international management of resources. We just want to go there ourselves first. Once again, I'm expressing my own views.
Thank you, Donna. Let me turn to Malak. Do we have questions from the social networks which we could ask, which you could ask to the two panelists?
First of all, thank you so much for the insightful information and presentation. Amazing. And I have myself a lot of questions, but I will start with the audience, and maybe I will ask only one question. And the first one is, who will approve the safety zones? Since we were talking about the safety zones, who will have the competency to approve these safety zones?
What a good question.
Yeah, it's a great question. I mean, you know, the Artemis Accords does talk about the parties will continue to work together and refine their arrangements. It doesn't actually say the process of formally approving it as agreed between themselves. It does give some criteria, as Donna mentioned before, about reasonableness, and it's got to be temporary, and it's got, you know, you've got to look at it in changing circumstances. So I'm sure if it was just up to the 8 or 9 signatories, and there may be more, they will find out, they will find a way, a process. But that, you know, ignores, to use Donna's expression, the elephant in the room. The elephant in the room being there are potentially another X number of countries who will be looking potentially to engage in activities in those areas because there are certain areas of the moon that will clearly be more attractive, if you like, for activities than others. Enforcement then becomes a really two-edged sword in terms of what it means. Okay, the Artemis countries will work out, you know, an enforcement regime as between themselves, but enforcement as regards other actors who have got no connection to the Artemis Accords begins to raise some difficult issues. And it, you know, it's interesting that the safety zones are under a heading of this, again, another word that I dislike, deconfliction, you know, but this, if it's not handled properly, is an area that could well give rise to conflict, because, you know, we've learned the lessons on Earth. Wars in the past, many wars in the past have been over resources and claims of areas of resources. And the last thing we want to do is project that sort of idea into space. And so enforcement as between the signatories, they'll find a way, but that's not really, for me, the main issue. The main issue is getting a global understanding of what any impact is if one country says, hey, I'm working here, I'd really like it if you didn't interfere with what I'm doing here. That's really the issue, I think.
Thank you so much. Yeah, Mrs. Donna, do you like to add something to?
I think I did, but I've forgotten what I was going to say because I got involved with what Stephen was saying. So I'll pause.
Oh, I hope you agree, Donna.
Of course, I do agree.
We can talk about this later.
Okay, the next question is a question asked by Professor Andreas Locke. He was our last panelist in the last show, and I'm sure you are familiar with his work. He's working on planetary protection also. And his question is, what is in the Moon Agreement that is hardly signed by countries? And for me, from my point of view also, I read like all the literature, you know, sometimes point to the failed agreement always, or the agreement that it's left alone or left apart. So the question is like, why it wasn't signed by most of the countries?
Yeah, there is a bit of a story behind why it wasn't signed, and you know, as Kai-Uwe pointed out, that it was adopted by the General Assembly, but I understand that there was some strong lobbying at the last minute in the United States, and then once the United States didn't sign, then others didn't. But I would hasten to add that there are more signatories to the Moon Agreement than to the Artemis Accords at the moment. That may not continue that way. Do you have more background on that, Stephen, that you wanted to mention now? I mean, I will just say that I'll add that the two things were the common heritage and the equitable sharing of benefits, which started to seem too socialist for some.
Yeah, and I agree. And also, just to put it back into that, my very first comments at the beginning, let's put this in a broader context where these discussions were coming at a geopolitical time when through the UN process of decolonization, all these new countries were emerging, and they were former colonies. If you look, the example I always give, if you look at the continent of Africa, I think there are now 53 countries in Africa. Every one of those countries, bar one, and your homework for everybody is to find out which country, if you don't already know, every one of the countries in Africa, bar one, were former colonies that emerged through this process of decolonization. And the thing about colonies, to a greater or lesser degree, is that they were largely utilized for their resources and not necessarily in a sympathetic way by the colonial powers of the time. And so as these countries emerge, and then you say to them, we are dealing, international law is now dealing with new types of areas that are not territory, they're beyond national jurisdiction, and yet there's great benefits and quote unquote resources to be garnered from them, you know, the deep seabed and outer space, for two examples. And then you say to them, of course, when it comes to space, only the, you know, 1 or 2 or 5 countries can actually do some of these things. They will be very fiercely independent in saying, well, you know, this is different. This is not territory. This is an area that, you know, should in some way, shape or form be globally managed. And that gave rise to the concepts of common heritage and equitable sharing. So it's a political framework. You know, there are long memories for that political framework. Even though the world has changed, there are many more spacefaring nations, albeit still with different capabilities. There are long memories, and you know, you speak to some people in the United States, and you know, you could speak to them and extol the enabling parts of the Moon Agreement and say, well, look, actually, this enables you to do things. It's a positive, you know, notwithstanding whatever argument you'll give, there is absolutely no way from a policy viewpoint that certain people will accept ever that the Moon Agreement is part of the core treaties. And indeed, some countries, when they talk at COPOS, talk about the 4 core space treaties. We all know there are 5, but they talk about the 4 core ones, not including the Moon Agreement. So there's so much political, dare I use the word heritage, associated with this issue, that sometimes that takes away from the fact that there are some rationalities in looking at the lessons learned from not only that instrument, but many other instruments.
May I also step in here and give an advice to the Australian government? Now, we only have 18 signatories and state parties to the Moon Agreement. These 18 states could set up a regime or the foreseen regime. Why don't you do that? Just as a thought experiment, if these 18 countries would sit down in a state conference, state parties to the Moon Agreement, and work out a regime, do you think, well, I'm convinced that a lot of other countries would then step in and also sign and ratify the Moon Agreement to be part of that, because only this, much more than the Artemis Accords, would then guarantee that you are on the legal safe side. Talking from my own experience, we are also asking ourselves in the German government, why aren't we a signatory and a state party to the Moon Agreement? We are, and you made this comparison, we are also having our claims already in the deep seabed mining, which is exactly the regime we would also or could foresee for the Moon Agreement. So why aren't we state parties? And we talk with the other ministries, with the foreign ministry, and everybody says, oh yeah, there's nothing wrong with the Moon Agreement. We just decided 40 years ago not to sign it. We can't really remember why. And since then, it's such a big task and such a hassle to put it through Parliament. But there's absolutely nothing wrong with the Moon Agreement. So why shouldn't these state parties to the Moon Agreement not set up a state conference and figure out a regime?
I completely agree with you, and I think it should be done. However, of course, you have to consider your political relations with other countries and what impact that would have. So I imagine that's top of mind, relations with other powerful neighbors. I have certainly been spruiking the Moon Agreement as a superpower for space resource companies because of the phrase that I highlighted earlier, that in the Moon Agreement that says states parties are specifically and expressly allowed to extract and use space resources, moon resources, in order to support scientific missions. So to my mind, that means that if you were on your way to Mars and you extracted some water and used it as fuel, completely, clearly legal. You don't even need to talk about ownership. Doesn't matter, I think that's ownership is a furphy. You are expressly allowed to do it. Whereas for those who aren't signatory to the Moon Agreement, perhaps it's not so legally clear. Whereas for Moon Agreement signatories, it's very clear that that is currently allowed. So, Stephen?
Yeah, if I could just add, a couple of years ago at Legal Subcommittee, there was as there is every year, a symposium organised by the International Institute of Space Law together with the European Centre for Space Law on the Moon Treaty, on the anniversary of the Moon Treaty in 2019. And there were a lot of speakers at that symposium, and I had the honour of doing the final talk at that symposium about reflecting on the Moon Agreement, past, present and future, and made the point that firstly, in 2008, 8 or 9 of the Moon Agreement parties, not Australia, made a statement about how they interpret it and the advantages of the Moon Agreement. But the Moon Agreement allows for a review conference. It allows for the establishment of a regime once, when the resources are about to be exploited. And so that's an issue of interpretation. But so there's nothing stopping those parties making a statement or having a review conference, or indeed, even if they believe it's appropriate, setting up a regime. If you look at the 18 states parties, they're a fairly disparate group of countries from different UN regions. And so obviously getting them to agree or largely agree will be one issue, but there's nothing stopping them doing that. But I think, as Donna quite rightly says, this is not a legal issue, this is a political issue. But, having a foot in the Moon Agreement camp may be seen as some. And I recall after that symposium in 2019, I was approached by perhaps a dozen delegations who all expressed at least an interest in exploring more the Moon Agreement. Now, that hasn't translated to additional ratifications. It may never. But I think Kai-Uwe's point is absolutely valid. People are now seeing in this environment we are that the Moon Agreement is not a failed treaty. It may be something, an extra tool, but certainly, an instrument which contains interesting lessons that one should keep, in the oven, piping away, because just one doesn't know where we'll go. Although I'm hopeful with the discussions that I have the honour of co-chairing that ultimately there'll be a working group on the issue of resource exploitation, and then ultimately there'll be, in these big issues, a buy-in from the international community, the broad international community, and we'll see what that looks like. But I think your point is absolutely valid, Kai-Uwe, that is international law for those 18 states parties. They have rights to do things, and I'm sure they are looking and probably liaising with each other as to how to move forward. It's complicated by the fact that some might join the Artemis arrangements. Perhaps it's complicated, perhaps it's not. But I think it's certainly at least one other factor amongst many that needs to be taken into account.
Well, certainly the other thing is they don't just have the option, they actually have the obligation to create that international regime prior, just before exploitation is about to become feasible. And we're really on the doorstep of that already. So I actually think that the Moon Agreement countries should be.
Yeah, I mean, that's the point. I mean, those words allow for a broad interpretation. Are we going to have massive, forgetting the politics and the law for a minute, does the technology really allow for massive, large scale exploitation of the scale that industry is talking about in the foreseeable future? We don't know. So those words feasible give rise to different interpretations. But if they believe that we're at that point, yes, they amongst themselves will create a regime which gives the states parties to that treaty certain rights. So we'll see.
Thank you
It would certainly
much.
give more clarity. Yeah, I'll stop. Yeah.
Thank you. Actually, the other questions, they fall under the breach of obligation, either the Moon Treaty, Moon Agreement, or the Accord, the Artemis Accord. So in case there are like different scenarios from different questions, but the most prominent one is actually if there is a Moon Agreement states signatory and is in the Accord, Artemis Accord agreement a party. So if that state breach the obligation of either the Accord or the Moon Agreement, how the other states will react? The ones that they are a contracting party in the Moon Agreement, for example. And we know there's a problem of issue of enforcement, issue of what would happen if one state will breach any obligation under the international space law. So this is what these questions are about.
Well, yeah, I know we're probably going over time. The Artemis Accords, of course, are not binding instruments. They're expressly not, but they do clearly have legal value and they clearly commit the signatories. So as between themselves, if one of the states parties really was in violation, I'm not sure what the consequences would be. it wouldn't be international law consequences, but there would be consequences. But on a treaty, I mean, the international law is clear. You know, if a party breaches its obligations, the laws of state responsibility apply. Those mechanisms exist. Of course, it's a political decision as to whether you want to enforce your rights, and states very rarely want to take action for a violation of treaties. You know, much more they want to negotiate. But it's pretty clear that if states violate a treaty, other states' parties have particular rights under the laws of state responsibility.
Thank you very much. I think we wrap up him.
Yes, yes.
Thank you.
Kai-Uwe?
Thank you. For wrap up, I would just like to thank the two panelists. It was absolutely inspiring. It was not only interesting and thoughtful and full of information. That's what we can easily expect from such two super interesting lawyers. It was also inspiring, I must say, inspiring to the extent that it reached out much further than just a legal discussion. It was very political. Also, it went into ethics, I must say, and this made this discussion particularly valuable for me. I learned a lot, and I got inspired, and I hope it was the same for the audience. Thank you.
Oh, thank you, everyone. Thank you so much, Stephen and Donna from Australia. It's nighttime. I appreciate your time. And Kai, again, for your amazing support. And thank you for Malak, our co-host, and Yara, and the rest of the audience that are viewing. There's nothing more to add. It was a very, very valuable.
Actually, I would like to add something to just say something to Professor Stephen and Mrs. Donna, and also Professor Kai, to thank them, because actually there's one point I would like to stress on is the way how Yuri Gagarin spacewalk and Neil Armstrong first steps on the moon were the sparks to ignite ambitious human prospects on space travel. Today, we are witnessing an unleashed and limited possibilities for humankind's expansion in outer space. The next giant leap is a permanent human activities on the moon and outer space. So amidst this paradigm shift in space exploration, propelled by disruptive technology and various other trends, we are witnessing an attempt to fill the international law gaps. So this is one of the series to address legal issues pertaining to international space law with great scholars, professionals who are adding to the progress of this field. And I recall here, given that the teaching of most highly qualified legal scholars and professionals is one of the subsidiary sources of the international law as per the Article 38.1 of the Statutes of International Court of Justice, the United Nations judicial body. And dear panelists, it's an honor and to have you in the show, as you are among these scholars and professionals. These are my last words, and I give you the mic hand to say who's coming next week for the next series.
Yeah, we invite everyone to join Space Entrepreneurship with Mr. Jeffrey Manber. He's the founding father of commercial space. So alongside with VC, which we're not revealing yet. So I know everyone's still on holiday, and I am also. As soon as it's ready, we'll share that with you and you can register. So thank you very much, everyone. Again, stay healthy, stay safe, and a successful 2021 ahead.